The Supreme Court, by a 7-2 vote today, siding with a Colorado baker who had refused to bake a cake for a same-sex couple, arguing that it went against his religious beliefs. Now, I spoke with this baker, Jack Phillips, back in 2015 when all of this first dusted up.
My case is the government is trying to force me to violate my personal religious freedom and, create a cake for a ceremony that I have objections to.
You won't make a cake for a gay wedding,
correct?
Right? You will for a heterosexual one.
Right now, we're not. We're not making any wedding cakes. So that's taken a pretty good chunk of my business away.
When you hear all the nasty things that have been said about you in the phone, threats and everything else, and you've been portrayed as this religious freak who's, all but a racist, how does that make you feel?
There are comments by people who don't know me, who haven't taken the time to come into my shop and get to know me. They're just making an assumption that that's what I am. But that's still beside the point. That what this case is about is, as an American citizen, I do have First Amendment rights.
All right, and that was what was at stake here as this went all the way up to the Supreme Court. Again, justices by a 7-2 vote ruling in favor of the baker. They said that it ultimately came down for battling between the respect for sincere religious beliefs versus practices that subject gay persons to indignities. Ultimately saying this is not going to be a precedent-making case, that others in the future will be on a case-by-case basis. The read now from former Justice Department official Robert Driscoll. I guess the justices were dancing on the head of a pin here, but what do you make, Robert, of where they came out on this? They kept seemingly stressing this was not a precedent-making case.
Well,
what does that mean?
I think what they're talking about is that, well, there is precedent. It's a narrow precedent, that they didn't decide forever and for all time that laws such as Colorado's are unconstitutional. They didn't decide that bakers never have to make wedding cakes. What they decided in this case was that the tribunal, the civil rights tribunal that heard this case, was itself hostile to the religion of Mr. Phillips. And I think Justice Kennedy's opinion took great pains to point out that these are the people making the decisions themselves, compared him to a Nazi, compared him to racists, and was clearly not open to treating his religious beliefs sincerely, and that was the bigger problem. A couple of the justices pointed out in concurrence that the same tribunal had allowed bakers to not bake cakes that had anti-gay marriage messages on them. They said, I find that offensive, I'm not going to make that, and that same kind of parallel case had gone to the same tribunal, and they had decided the other way. And so there's some evidence that really what was driving the tribunal was a hostility to Mr. Phillips' religion. And so, I think that they decided in this case he wins. But they're obviously leaving open the question, and I suspect they gave pretty strong hints as to how it would come out, that if there's a broadly applicable law, a straight public accommodation law, where you don't want to serve gay people, I think that would likely be upheld. And what's different here is this creative process in baking the cake made it complex, but also makes it a narrow decision.
To your point, Robert, two liberals on the court, Stephen Breyer, Elena Kagan, went along with the 5 conservatives on this. The 2 justices, Ruth Bader Ginsburg and Sonia Sotomayor, did not. What are we to make of that, particularly the 2 liberals joining in the majority opinion?
Well, I think the happiest person has got to be Chief Justice Roberts, because I think he wants people to view the court as not necessarily a partisan place. And I think that hopefully a 7-2 decision will cause people to look at the decision and say, well, maybe there was some actual constitutional basis for it here, where people, I think, when it's a 5-4 and conservative justices vote one way and liberals the other, they tend to think that it's all just politics, which those of us who practice law hope it's not. But I think that the strength of Phillips' case is demonstrated by the fact that Breyer and Kagan went along with it. I mean, they agreed that the tribunal in Colorado was hostile to his religion and that he deserved to have have his religion taken seriously, and that he has a First Amendment right to not be compelled to make statements about marriage he doesn't want to make. So I think that it's a good decision for the court, and I think hopefully it'll turn the temperature down in the country a little bit. I mean, these discussions are a little bit academic in some sense, but I think seeing a 7-2 decision hopefully will make people realize there's actual legal analysis going on here, not a straight political play.
You know, I remember some years back when I had talked to Jack Phillips, the baker involved here. He had stressed to me, I'm not anti-gay. I'm not making a judgment about gay people. I just, on religious grounds, I don't want to honor same-sex marriage. I'm paraphrasing his argument at the time. So he was sincere in his beliefs, at least I believe, and obviously the justices believe that as well. But couldn't someone take advantage of this decision, Robert, and use it as an excuse to mask otherwise anti-gay, behavior?
I think it would be hard to do. I mean, obviously people can if people are operating in bad faith, but I think it would be hard to do in this case because it really wove together a couple of different strands of the First Amendment. I mean, there's a religious freedom strand of the First Amendment that you can free exercise of religion, but there's also a First Amendment strand of the First Amendment. And that First Amendment strand needs to be balanced as well. And I think in the average case, that First Amendment strand isn't there. So in a straight public accommodation case, if I run my diner and I don't want to seat gay folks in violation of the state law, I suspect the court would have no problem with upholding a fine against that business owner, notwithstanding his religious beliefs. Broadly applicable laws are generally going to be upheld. I think in this case, there needed to be some analysis as to whether there was a least restrictive way to do it or some other things. And in the course of doing that analysis, the Civil Rights Tribunal in Colorado just kind of blew it by being open in their hostility towards his religious beliefs. So I wouldn't be that concerned. And also the market takes care of these things. 99.9% of business owners want as many customers as they can get, regardless of sexual orientation, religion, race, or anything else. I think we're talking about a very narrow subclass of people who hold religious beliefs sincerely enough that they're willing to forego business. I mean, look at this guy. He stopped doing wedding cakes entirely. After this decision in order to avoid violating Colorado law. So I think that on its face is pretty good indication that his beliefs were sincere.
All right, Robert, thank you very, very much. The former Department of Justice official, Robert Driscoll, on a decision that still has ramifications, but again, as he pointed out, is very narrow and pinpointed in its scope here. So whether this is making any sweeping indictment against gays or an overwhelming victim for religious enthusiasts, that is way too premature. There's simply no way to make that connection just yet. And the justices did, to Robert's point, go out of their way to indicate that would not be the case.